received, well, improperly served, but apparently an amended petition of 49 pages, along with new financial declarations, et cetera, yesterday, and obviously haven't had a chance to review those. And they're not in reply to anything, but if petitioner wants those to be ruled upon, then obviously this needs to be struck. The petition was timely filed as for post-secondary support. So if the hearing is simply reset once the information is properly gathered, then there's no prejudice to anybody.
All right. And any response?
I'm not sure I understand what he was asking. I apologize. I don't have a lawyer, so I don't know all the ins and outs.
Sure. So it looks like there was a modified an additional petition to modify child support that was filed by you. The stamp date was the 24th of July.
Yes, I did an amended one. I had to drive to Washington. I live in Oregon, so for me to get that, I had to drive up there and put it in, and it's difficult. And
there, Mr. Gross is just indicating that they received it. Did you say yesterday on Monday?
Yeah.
So they are asking for more time to respond to that. For a set over, I wouldn't imagine it would need to be too long of one. And additionally, you just made the comment that because it was timely filed, there wouldn't be any prejudice to any parties, meaning that it doesn't matter that one of the children is over 18 now. You filed it in time. So if it's ordered, it's ordered. It wouldn't impact.
Okay. So then we just need a little more time to review it and then make a decision. Is that what I'm understanding then?
He's wanting a little bit more time to potentially respond to the petition. Yes.
Okay.
And do you have any objection to that?
No. And
okay.
My question was, did you get the information that you needed to be able to look at?
I did. I didn't see any responsive declarations, which is what I'm assuming Mr. Gross is requesting the time to be able to do.
That seemed, if that's a reasonable thing to do. Again, I don't know what all the things are, so I assume that's a reasonable thing to do.
I will say that the matter was raised in a timely fashion, so there shouldn't be any issue with a ruling today versus a ruling in a few weeks. So I'll grant your request for continuance, Mr. Gross. I can tell you that. How much time are you looking for? Would the 16th work of August?
Is there a reason we couldn't just do it today? Is there?
Because he has by rule, he has an opportunity to review the materials. They just received it and respond to the materials. So
the 16th is fine, Your Honor, and I think that's appropriate because obviously everybody needs to plan for college. So let's get that done.
All right.
16th of August?
16th of August at 1 p.m.
Thank you.
All right. Thank you.
Does that mean we're done?
We're done for today, yes. And then anything that they file, they'll serve upon you. So you'll have their response as well. All right. Any other quick matters, strikes or setovers?
Your Honor, on number 2, this was a return hearing for a restraining order. I didn't receive anything from the opposing party. I don't see her present on Zoom. I don't know if she's present in the courtroom, but I just wanted to let you know I didn't receive a response, so I don't know what the posture will be today. So
I didn't see a response. I did have a quick conversation with Commissioner Carmi. I reviewed the rulings and reviewed your proposed orders. The proposed orders I have don't have any signatures on them, and I don't know if that was because of how they got to me, but they appear to comply with Commissioner Carmi's ruling. So I was prepared to enter those today, having received no objections.
We're not on for entry of orders today. We're just on for the reissuance of the restraining order.
Oh, and is this not Enerson and Anderson?
No, this is number 2. I'm sorry.
Oh, sorry. Mine are all jumbled in here. I apologize. I was so strike everything I said. The note I have here is I didn't see anything in the file regarding service.
She was served on the 13th, and that was filed with the court. I can tell you here. The proof of service was filed on
the 24th. So it came in yesterday. It must come in after I reviewed for today. So
it was. Yep.
I do see that. Okay. Is there, I don't have anything from you, so I'll have to draft that post after the docket unless you provided something.
I didn't. What I was thinking is we're already set for temporary orders and adequate cause on this case on August 8th. So what I was going to propose to the court is that if you could just fill out the reissuance form, the carbon copy form until the 8th, I think that makes most sense for efficiency and whatnot right now. So if your honor is willing to do that, I don't need to submit a form. I would be fine with that order.
A reissuance of a protection order to August 8th. Let me just make a note for myself. That's already on the docket for the 1 o'clock docket.
Correct, for temporary orders and adequate cause. Yep.
All right, I will grab one of those forms and fill that out and file it after court.
Gotcha. And just to be clear, it's just a restraining order reissuance within the family law case, not a DVPO. I just want to be clear on that. So
I will mirror because it looks as though
I can also have my staff just draft a new one of what we filed and email it to your JA if that would be more helpful. I'm happy to do that.
if you want to do that, that would be perfect.
Yep, we can do that right this afternoon. So
And then I'll just once I receive it, I'll get my signature on it and get it to the clerk's office.
Ms. Gunnell
Perfect.
present. This
All
matter was
right.
on in
Thank
front
you
of
very
Your
much.
Honor
We'll see you on the 8th.
for a trial.
Your Honor.
Ms. Carol Pro Se. I made a motion to dismiss at the time of trial for insufficiency in the pleadings. Your Honor, set it over with instruction for an amended to be filed if she chose to go that route. My notes reflect and the clerk's minutes reflect that if it wasn't filed by the 30th, then the court would grant a dismissal without prejudice. The amended was filed on the 7th. It was on for the 11th in front of Commissioner Carmi, since it was you who was the trial judge who put it on in front of Your Honor. My position is that they didn't meet the timeline required by the court to amend and avoid a dismissal, and it should be dismissed.
Good afternoon, Your Honor. I'm Jennifer Gunnell for Patricia Carroll. My understanding, and obviously Ms. Carroll was pro se at the trial and we were coming on later and trying to understand what's going on from the notes, was that it had to be filed by the hearing on the 11th and it was. So we would ask that this not be dismissed. And if there was any error, for what it's worth, Ms. Carroll was pro se and was attempting to find counsel. It obviously took her a while. It takes time. And in order to play catch up, I do not think that this should be dismissed at this point. And we'd ask that this be able to go forward.
All right. The court's ruling on the 22nd of June, and I'm reading from my notes, and then they mirror the notes, the minutes of the clerk. Ms. Carroll will file an amended petition. If the petition is filed, it needs to be filed no later than June 30th, 2023. If that is done, a new trial will be set. If it's not completed, the court will dismiss without prejudice. And it looks like she was about 7 or 8 days late on the new filing. So, Mr. Baldwin, I'm assuming that you're going to be handling this matter regardless of if it's a new filing or if it's I grant the amendment amended.
I think that's
Is that fair?
anticipated, Your Honor.
Okay. As frustrating as the situation is, I did review the amended petition. It does appear to fix some of the concerns that were in the initial petition. It doesn't list the time frame that she was married to another party. So given everything, and I think just for judicial economy, I'll allow the amended information, and I guess I'll defer to counsel as to if we want to set this for some kind of review, or if you want to note it up once discovery has been done for trial assignment.
I'll ask that no dates be set at this time. There was a limited notice of appearance. I don't know if counsel's staying on, but the court allowing the amended, I need to send it to my client. I don't want to create fees for him if the court was going to follow the prior order and dismiss. So we need to have a chance for him to review it and respond to the amended before setting it for trial.
That's fine, Your Honor.
Okay.
And also ask the court reserve on any fees, given that it was late. There was an additional hearing. So I'm not asking for any fees at this point in time, but there wasn't compliance with the court's order, and the set over from the 11th to today for Your Honor was to not have another judicial officer or commissioner make the decision, because Your Honor was the trial judge and should be the one making it. So at least reserve on any sort of fees for the delinquency and the filing pursuant to the court's ruling at the time of trial.
I think that's appropriate, so I'll preserve that right to raise the issue of fees 08 down the line on for just a review. All right, thank you.
Yes, Your Honor, had implemented visitation the last time we were before the court. It's currently supervised by a non-professional supervisor. I think Your Honor wanted to see how those visits were going and then come back before the court. I was going to make a request to set this matter over. It's my understanding that the child had requested to meet with his counselor after one of the first meetings or visits with mom, and that visit that appointment happened this morning at 11 o'clock. So my hope was maybe we could set it over a couple weeks. I can get something from the counselor if she's had any discussions with Marshall as to the visits, how they're going, if there's any concerns, and so on and so forth.
Ms. Roberts, any concerns with that?
Well, slightly, Your Honor, because the visits have been incredibly difficult with respect to agreements from the parties to supervise. As far as supervision, where they're held, what times they're held. Dad has unilaterally now decided that there's no phone calls. So no, I'm not willing to set this over. I have no objection to the court implementing some more specific terms regarding the supervision and putting in place specific orders, but that needs to occur today, not in 2 weeks. I have no problem if the court wants further information from Marshall's counselor, and neither does my client. However, that counselor has essentially refused to talk with mother. And in addition, it's really not appropriate for a treating provider to be weighing in at all on parenting issues other than to get feedback from the child. So to the extent that the provider is weighing in on custody and parenting issues, that is completely outside of her lane. And she is only a treating provider. She is not an expert, has not been designated as such. And so to the extent that Ms. Bliss is going to provide information from the counselor that would include information that would only be allowed to be reviewed by this court in the capacity of an expert in custody and parenting evaluations, we would object to that. So I would ask the court to provide more direction as far as who the supervisors can be, and as far as the times and days for that supervised visits. And I would also ask the court for specific orders regarding my client being able to maintain the phone calls she's had. And then I have an update with respect to the reunification therapy that Ms. Ravina had recommended, or I'm not going to call it reunification because it's more like it's kind of a hybrid between reunification / family therapy, really just to have mom and Marshall have an opportunity to have a safe place to kind of work through any issues together. The two providers that Ms. Ravina recommended in her report have indicated to me that neither are available. My client has reached out and done some research and obtained, it's my understanding that there's a counseling services training institute in Longview that has availability. She's been working with, I'm going to butcher his last name, but his name is Joe and his last name is Gionati, I believe is how it's pronounced. And my understanding is that he has availability and could start the process, coming up shortly. I just received this information from my client and I will provide that to Ms. Bliss. But in essence, and I don't know if Ms. Gravina is on, but it may be exceedingly helpful for Ms. Gravina to supervise one of the visits, Your Honor, because, there's been allegations that the supervisor that my client was wanting to use wasn't supervising. My client believes, and the supervisor I received information this morning believes that somebody was actually monitoring that visit and who shouldn't have necessarily been there, or that there's been sort of inappropriate discussions with Marshall following the visits. In essence, right now, both parties are having a supervisor at the visit. So Marshall has mom and then a supervisor selected by dad and a supervisor selected by mom. I mean, that seems overkill, Your Honor. But that's the only way we've been able to keep these visits going forward. So further direction in that respect would be exceedingly helpful. And again, I don't know if Ms. Gravina is on. I don't see her. but possibly an order from the court that requires Ms. Gravina to supervise a couple of visits would be exceedingly helpful if we're coming back on this issue. Thank you, and sorry for the long-winded response.
Ms. Bliss.
And Your Honor, I think first off, having Ms. Gravina supervise a visit is beyond her scope as the guardian ad litem. And frankly, with her not even being on the registry anymore, I don't know if that's really a good idea. Looking to some visit issues, obviously, Ms. Roberts has encapsulated those pretty well. That said, the visits have been occurring pursuant to the order. Yes, there were some hiccups getting it scheduled, but Your Honor wanted supervision in place given the length of time that there was no contact between mom and child. The concerns listed previously by Marshall's counselor, who now Ms. Roberts has an objection to providing any sort of input to the court regarding his mental health with contact with mom. Your Honor wanted us to establish reunification counseling, but didn't want visits to stop or stay stopped in the interim. So you did order supervised visitation to occur. And I can say that those have been occurring. Yes, there have been hiccups, but I think largely those have been resolved with the implementation of 2 supervisors. Yes, I agree that that's overkill, that we shouldn't need 2 supervisors for visits. However, the conflict between the parties, the allegations going both ways, it was my suggestion that this occur to alleviate those concerns moving forward. I think that that's basically what's before the court today, is we were before the court as to what the status was regarding reunification, which I understand based on Ms. Roberts' representation that Ms. Hill has found someone. Again, this is the first I'm hearing of it as well. I will instruct my client to reach out to this provider and begin this process if that provider is available. However, that before the court today was just a review on reunification and visits. So I would defer to the court if you want to make any specific orders. I would say that the parties, albeit going through attorneys and incurring significant fees to arrange everything, have been able to work out these visits. They have been occurring as scheduled.
Really briefly, Your Honor, I just want to address the issue of Ms. Gravina. I don't believe it's beyond her scope at all. In fact, I believe the GAL order clearly defines, and part of her role would be to observe mother with the child, and it would be wholly appropriate for her to do so in the context of what is going on currently, just like it would be absolutely appropriate for her to see Marshall in Dad's home. So I don't believe that's beyond the scope of her role at all. In fact, she frankly would have been doing that, barring the court's order, with respect to contact between my client and Marshall. So I think that's absolutely appropriate. And with respect to her not being on the registry, I mean, unless the court's going to appoint a new guardian ad litem, I think, which I'm not sure would be, cost effective or helpful at this point, given the amount of time Ms. Gravina spent on the case. I mean, we could check with Ms. Gravina, but I think that information would be fully helpful to the court. And with respect to the issue about the counselor and her information, there's an objection on my part to the counselor providing information regarding Marshall's mental health.
Okay, I'm going to stop you, Ms. Roberts. I don't have anything. So the last thing that's in the file is the minutes from the last hearing. So you are asking me to make drastic changes or make more specific changes when I have no evidence of anything other than comments that visitation's been happening. They're not as great as we'd like them to be. Okay. And some allegations that there's conversations before or after visits that shouldn't be happening. Okay, and that shouldn't, we have a temporary order in place, so those things should not be happening. The child should not be engaged in any conversations about the parenting plan, about visitations, other than very standard things are going okay conversations. I am not going to order a GAL to do a supervised visit. This is a partially county pay case, so the county would be essentially paying for a supervised visit for Miss Hill. That's not going to happen under the circumstances that we're in right now. These are adults that had a child together. There needs to be some commonalities established for the best interest of the child. The child shouldn't be a pawn used by either party to get what they want, achieve certain things, talk bad about the other person. I, at this point, ordered up to 3 hours a week of non-professionally supervised visitation between the child and mother. That counseling should continue with child, the counseling that the child was already in. And if there's an additional counselor that mom thinks is appropriate, I'm happy to hear about that. And it sounds like if once Ms. Bliss gets more information about that, her client may be interested in utilizing that additional counselor. At this point, I don't know what more specifically you need me to say other than these people need to grow up and do the best for their children. Period. If you want me to split Tupperware, someone's going to get a lid and someone's going to get a bowl and nobody's going to be happy. If you want me to get that detailed in this order, then I will, and everybody's going to be upset. And I'd rather not do that. So since I have nothing filed in this case, I'm glad that visitations are happening. But I'm not inclined to do anything else today. If you want to file something and note this back on the docket, I'm happy to review it and make further determinations. Anything? All right.
Can we set a review date, Your Honor, please?
When would you like to set a review?
Well, I would like to set a review. Does the court have availability the week of August 14th?
I have the 16th of August available.
And I guess my question is what exactly are we?
I'm sorry, the
reviewing?
15th of August is available.
Supervised visits, because the recommendation is to go back to the normal parenting schedule. And we're going to be months out to get a trial date. So I would like a review to deal with any changes to that supervision.
If you filed something, that's great. So I'll set a review. So you don't have to note it up. I'll set a review for August 15th at 1 p.m. Yes.
Oh, you beat me.
Someone's on vacation. 23-3.
Yes.
This is a motion.
To
Ms.
suspend.
Baldwin.
Yes. Thank you. For the record, I'm Chelsea Baldwin. I represent Kylie Wisher. This is our motion to suspend visits. The history here is important, and the court is not that far removed from the history of this case. But the court will recall Mr. Wishart was initially dishonest with the court about his drug usage and whether or not he would be clean. Was found to be using cocaine. He was dishonest with the guardian ad litem until essentially he was caught, both with the positive hair follicle, but additionally with other information where he didn't disclose that. And it was only when she came back to him and said, hey, what about all these other instances? And only then did he admit those to her. Similarly, dishonest with the evaluator, not disclosing information until he was caught essentially through the collateral contact. So we have essentially a fairly clear history of Mr. Wishart saying what he wants to say and what's convenient at the time. The underlying order is clear. It's Ms. McLean's order. If you're off work, you have a very limited amount of time to respond to a request to provide a hair follicle and engage in drug testing, which is appropriate given the fact that we have somebody who had a positive test for cocaine. And what we have here now is multiple failures. So this is not realistically brought before the court on just one single failure. The court made its order, that he had to get a UA once a week. Mr. Wishart, that on a Tuesday you made that order. Mr. Wishart doesn't do that. He just says, not going to do it this first week. I'm going to sit on my hands, do nothing. End of that week, my client requests the hair follicle, doesn't do that.
Your Honor, I guess, Your Honor, if I may I interpose an objection?
Sure.
The argument that counsel just made in regards to my client not participating in a UA the first week was not information that was pled in the initial motion, so we didn't have an opportunity to respond to that. That was new information that was contained in the reply declaration, and I would ask that the court not consider that argument, again, because that's something that should have been raised in the initial motion to allow us to respond.
They filed their clean hair fall or their clean UA single one. I think that's appropriate to reference the timing of that.
Go ahead, Ms. Baldwin.
So, Mr. Wishart doesn't do his UA. My client goes appropriately through our family wizard, requests the hair follicle at the end of the week. He has essentially 5 hours to get that done. She requests that at effectively noon. She leaves it open for the rest of the day until they close, until business closed, even though that's significantly longer than he would have been provided per the court order, never shows up. And then similarly, he arrives the next week, does an observed UA or unobserved UA on his schedule when he chose to, when he wanted to, and again, unobserved. So we have somebody who is waiting. We have the A, no initial test, B, we have refusal to do the hair follicle, and then C, he waits essentially the requisite period of time to be able to produce a clean UA. And says, well, gee, that's how it is. I'm just not going to do what the court order requires. Again, cocaine was not the only history here. My client disclosed a significant history of drug abuse of several different drugs. Mr. Wishart himself acknowledges prior troubles with illegal substances. To my client's knowledge, there's no treatment's been on board. And this idea that I can just sit on my hands and not do anything, we're all aware there's AA and NA meetings occurring regularly. You don't need a prescription to show up for one of those types of meetings. We don't have any of those. All we have are Mr. Wishart are excuses. First excuses is I'm out of town. That does not appear to be true. Second excuse he uses is I'm sleeping. So even though these are the hours where he should have been up and awake, and my client says she had a history where he was working similar types of hours, and is able to say, no, he would have been up. We had a long history of him working this type of shift work. So again, my client says this is not a new situation. He claims, oh, I didn't see it. I was sleeping. Please, excuse it away. And then the last is I didn't see it. Like I just didn't see it at all. And arguably right there, which is it? We already have 3 different stories in a very quick period of time. The idea that he didn't see it, my client completely dispels. She says, look, the reason why the parties are using our family wizard is it provides you multiple ways to be informed. It provides 3 different ways. It sends essentially a text message or pop-up to your phone. It sends you an email, and it has badge and banner notifications on your phone. And my client says he would have had to turn them off because they were automatically on. So the default presentation is that they start on, and you have to say, no, I don't want that notification. And it's very easy for somebody to see that there's a notification and say, well, I'm just going to ignore it because that's bad news. And so it's easier for me to ignore that than comply. And that's what we have with Mr. Wishart. Again, the reality is that addicts lie. We all are aware of that. They will say whatever they can to get out of the trouble that they're in at the moment. And that's really what we see is one excuse after another, neither of which are really backed by anything. And a key when we look at, does this person have a problem? Is it impacting their life? And we do see that. We see Mr. Wishart failing to make visits where he's not granted that much time in this parenting plan. I would argue he's granted 6 hours, and he just doesn't show. If this is a visit with his family and he has a no call, no show, his family is making efforts saying, where are you? What do you get to the visit? Doesn't show up. Again, direct impact on him, but direct impact on child as well. So in this case, we still don't have a observed clean test. From the date where you made the order where you said you need to be doing this, still don't have one. You have nothing. He's not clean. And I would argue the court was incredibly gracious with him. And if I was to use a lay definition of grace or gracious, it's undeserved favor. The court said, hey, you have a dirty hair follicle. I'm going to keep allowing visits. But what does he do with that? And I would argue, if you looked at his SUD evaluation, is that he's ambivalent to change. He took that grace and went, I don't really have to comply. And that's what you see is him not complying. Blows off the first UA, doesn't do the hair follicle, does an unobserved UA, and blows off a visit. No call, no show. These are all indications of somebody who's just ambivalent, and that's not appropriate. It's not fair to the child. Child deserves somebody who's committed to sobriety and who is getting on track. And that is not what is indicated here. My clients followed the correct procedure, but we're here today because this is where we should be. And the court should suspend visits. What I'm asking the court to do is to do that, to suspend visits. Mr. Wishart needs to get serious. The court should order him to complete a hair follicle that's a minimum of 12 panels today. That should be at his cost, not my client's at this point. We should suspend visits for 2 weeks and come back and look at that hair follicle. If the numbers are going down, then that is what it is. If the numbers are going up, that also is what it is. But we can reevaluate that and him getting engaged in treatment at that time. That is a fairly limited sanction in time, but it allows us to have a better window on what's happening with Mr. Wishart, especially given the posture of where we stand today and sort of his, again, ambivalent nature about how he's going to move forward with his sobriety. And additionally, the court should award fees in this case. It's not reasonable that we're here. And the excuse is essentially I should be able to abide by the court's drug testing whenever I feel like it. That's not fair to my client. There's a significant disparity in income between these two folks.
Thank you, Ms. McLean.
Thank you very much, Your Honor. First off, Ms. Kale had sent an email to all of us sometime this last week Unfortunately, I'm working off of digital because I don't have the ability to print where I'm at. So I know that there was an email that she sent. I'm assuming that the court has reviewed through that as far as her input because she was not available today. I had requested, she had actually requested that it be set over to August 1 since we're before Your Honor next week for presentation of the order. That was not agreeable since my client was unwilling to voluntarily suspend his visitation. So you can see from Ms. Kale's email that she believes that it would be in Addison's best interest to continue her visitation, that it would not be in her best interest to suspend visitation. I guess my first question in regards to Ms. Kale's email, since the court has considered that, is the court willing to print that off and have that filed in the record, or do you want me to instruct my staff to have that printed off and put a cover sheet on it and have that filed in the court file?
I think it probably should be filed in the court file with a cover sheet. Would you agree, Ms. Baldwin? Yeah.
Okay. I'll ask.
You're going to have your staff do that? Is that what
I can have my staff do that?
Okay. I think that's appropriate.
Okay. So we were in court on July 11th. I'm sorry, on July 10th. That was the last motion that we had before Your Honor. Mr. Wisher did his UA on July 17th. And again, it wasn't raised in the initial motion about timing of that. The court ordered that he was to do that weekly. He did that within the week before his next, I believe before his next visit. My client was not asked about whether or not it was to be observed or not observed. I can, to be quite honest, I don't see on the evaluation or on that actual report where it says that it was unobserved. So I did have my staff check with them to see if it was in fact unobserved. They indicated that in fact it was unobserved. So I will instruct Mr. Wisher that he needs to pay the additional, I think it's either $20 or $25 to make sure that future UAs are observed. I believe he did his weekly UA yesterday. Again, it sounds like maybe that one was also unobserved. We will make sure that future UAs are observed. So that we have that issue resolved. I don't know, again, what that looks like in the actual UA report from the facility, because I don't even see a checkbox mark for that. In any event, we don't have any proof that he has done anything to tamper with that UA. The creatinine level is within the objective parameters to support that that's a valid UA. There's this allegation, unsubstantiated allegation by Ms. Wisher that my client would be using shampoos to try and clean his hair. Again, absolutely no fact. Again, when we go through the information from Ms. Kale tells you that he even offered that he hasn't even had a haircut since his last hair follicle test. My client did sign up for the Our Family Wizard. My client tells you, and Ms. Kale acknowledges and believes Mr. Wisher's statements that he was not receiving notifications, that he had to go in and actually sign up for the notifications. And so what happens is, my understanding of the timing is that Ms. Wisher sends a message through the Our Family Wizard on Friday while my client is sleeping, getting ready to go into graveyard shift on Friday night. My client doesn't see that until Sunday morning after his second graveyard shift. He responds to that thinking that she had sent that to him on Sunday and didn't realize until after the fact that she had sent that to him on Friday. We provided verification and he noted that the facility was not open on Sunday. So there was no way for him to dance on Sunday to be out of town, which he was up at, I believe it was a family gathering up at Swift Reservoir, someplace up in that location. And he told her that he was already scheduled to take his next UA for purposes of the weekly UAs on Monday and that he would do it at the same time. So he goes in on Monday, he does his UA, and is told by the facility that the hair follicle was time sensitive and he wasn't allowed to do the 5-panel hair follicle. Every effort that Ms. Wishart has to punish Mr. Wishart, she's using that effort. So counsel's argument today is that he needs to do a 12-panel hair follicle, which is, I think, $385, even though she only prepaid for a 5-panel hair follicle. What's the sense in that? It's only to punish him and to increase his costs in this action. I'm anticipating that she's trying to run him out of an attorney. And that's a huge concern. In regards to, so they said he couldn't do the hair follicle. So we don't have hair follicle results for him as it relates to that. Again, Ms. Kale tells you that there is nothing that suggests that Jonathan is a danger to Addison, that all of his visits have been appropriate, that Addison is bonded, that there have been no red flags, and that Addison gets emotional when the visits end. She does not believe that Jonathan would have intentionally missed a visit with Addison. He tells you with the stresses from the case, with the transition and trying, to be quite honest, I don't know how shift workers do their schedules, going from 2-day shifts and then transitioning into 2 graveyard shifts. And the next day was supposed to be his visit. He tells you he fell asleep. That's what happened. But Ms. Wishart does not give him the benefit of the doubt. And she immediately goes to, well, he's an addict, of which there's absolutely no finding by this court, or quite frankly, through his addict. Then the recommendation would have probably been for inpatient treatment, followed by outpatient treatment, or at least more than 1 month of recommended treatment. Speaking of which, again, we were in court on July 10th. On July 13th, and he provides you proof of this, he's able to talk with the triage nurse about scheduling an appointment. He had an appointment, I believe his appointment was today or is scheduled for today, with the SUD provider in Kaiser, in hopes of having this be able to be covered by his insurance. He doesn't have to come up with another $1,500 that he doesn't have for 1 month of treatment. Again, Ms. Wishart is not qualified to do an evaluation. Counsel is not qualified to do an evaluation. And yet the motion, the actual motion, although the substance of the motion does not speak to the request that he now be required to do 3 months of treatment, when the actual professional involved in this case recommended 1 month of treatment to be reevaluated at the end of that month to determine if there should be additional treatment. And the evaluation said that during that period of treatment, there would be, so that 1 month of treatment, there's the AAs and NAs. And now they're trying to fault him and say, well, he's not doing these things. Well, he's not started the treatment because he's trying to see if Kaiser can cover that. So if there's further instruction, if the court is wanting him to start those now outside of the treatment parameters and recommendations, then we will do that. But my client has been complying and is complying with the requirements of the court. So we, again, just see this as being vindictive, as being an effort to interfere with the child's relationship with her father. And to be quite honest, given the input from the GAL, who said that based on her review, she believes that it would be detrimental to Addison if her visits were terminated at this juncture, and that she does believe that he unfortunately fell asleep and missed a visit, that he has been following through with doing the UAs, and that she does not believe that he has done anything to interfere with that. Quite frankly, we think that this should have been set over to next Tuesday so that everybody would have an opportunity to fully hear and have any questions answered by the GAL, since she wasn't available today. We're asking the court to deny the motion in its entirety. We do not believe that we're here doing the UAs. As I indicated to counsel, they easily could have called my office on Friday morning and said, hey, we've asked your client to participate in this, and we could have then followed up with phone calls or whatever to try and make sure that he was aware that he needed to do this. My office always gives opposing counsel a heads up when there's a request for UA, because the whole goal for this court is to make sure that you have the information. It's not to play games and tricks and then come in on unnecessary motions. We want to provide you that information, and my client has been providing you and has provided the UA. We're waiting for the results from yesterday's UA, and as soon as we receive those, we will get those filed with the court. But we're asking the court to deny this motion, and if anything, we believe that if anybody's entitled to some fees, it would be my client for having to respond to this.
Thank you, Ms. McLean. Briefly, Ms. Baldwin.
Thank you. Requiring people to follow a court order that's their own attorney drafted. It's not vindictive. It's not made to punish. It's made to keep a child safe and to keep somebody, frankly, on track on their treatment. The idea that we would have to handhold Ms. McLean's client to get the treatment and the drug testing that was ordered isn't appropriate. The observed and unobserved has been on every UA I've received from occupational therapy or occupational wellness. It's on the sheet that they issue, not the lab sheet. So what was filed was the lab sheet, not sort of their sheet, because I don't think the lab gets whether or not it was observed or unobserved. That's not sort of their end of things. So that is usually indicated when you receive the correct one. AA and NA are free. Doesn't cost a dime to go to those types of programs. So again, we're in a situation where Mr. Wishart says, I don't have to do it. I'll do it when I want. The court's extended that grace and that favor to him, frankly, and his response is ambivalent. That's not appropriate given this posture. In every other drug testing provision, it's your visits get suspended first, and this hearing happens second. In this, the court has switched that and given Mr. Wishart grace and to allow the testing to happen and then the hearing. In the fact that he wasn't suspended first. But now we're in this position. The relief that I've requested is reasonable, it's appropriate.
All right, thank you. So this case is really unfortunate because I think the posture of both parties in this case is borderline appalling with how many, because it does seem like gamesmanship. I understand wanting to protect the child. The child is not with Mr. Wishart without a supervisor. Arguably, any of the supervisors are not going to want any ill will to happen to that child. And so that should be their first and foremost protection is to that child. I do very much understand the concerns. I think Mrs. Wishart, I understand her feelings and concerns about how this case has progressed. I don't know that everyone assumed that we would get a hair follicle that showed cocaine. I don't know that everyone assumed we would get UA at his initial SUD evaluation that was positive for alcohol. Those are things that I don't think anyone anticipated, and frankly do hint at a problem being bigger than what anyone's admitting. I do want to ask one clarifying question. When he did his SUD evaluation, we'd already had the hair follicle results, correct?
That's correct.
And those were not shared with that evaluator. Is that also correct?
They were shared by my client with the evaluator.
Okay. So the evaluator knew of that results when making final recommendation? Yes. Okay.
Yes.
And to be very frank, I'm concerned about missing a visit as well. I don't see how that happens. I just don't see how that happens. There's people that crawl through glass to see their kids, especially when it's limited time. So I'm really kind of concerned as to why that happened. I don't like this case. I don't like this situation because it seems like there's no way these parties are ever going to work together, and that's only to the detriment of the child. That's the feeling I have about this case, and I hope that changes. I am going to order that Mr. Wishart get a hair follicle this week, the same type that was requested by Ms. Wishart at his own expense. That needs to happen by close of business tomorrow.
So that would be I just want it clear on the record. My understanding is that was a 5-panel hair follicle exam.
Ms. Baldwin, is that what your client prepaid for on the 14th? I don't recall it being specifically stated in any of the declarations.
I don't recall offhand. I can double confirm and I can email Ms. McLean after docket.
Okay. So whatever Ms. Wishart ordered or requested on the 14th, Mr. Wishart needs to do by close of business tomorrow at his own expense.
So if you look at the email that's attached, the last Our Family Wizard report, it says her email to him on July 14th. I prepaid for a 5-panel hair follicle drug test at Performance Occupational Health today.
I do see that. Ms. Baldwin, do you see that? Are you comfortable with it being a 5-panel then based on that information?
That's fine.
Okay. So 5-panel for Mr. Wishart by close of business tomorrow at his own expense. I think the results for the last one were about 8 or 9 days out, so we may not have that for next week, but I want that done. If we can get results, great. If he can do it today, even better. That ups our chances of getting the results of that. And there's a request for 2 weeks of suspended visits and the hair follicle. I am going to order the hair follicle, and I'm essentially going to suspend visits until we review next week on the 1st.
Just so the court is aware, I think that Ms. Kale had scheduled to view the visit, which I thought was scheduled maybe for July 28th, but I need to open up my emails. I might be able to look online or on my phone.
Are you aware of that, Ms. Baldwin?
I've seen emails associated with that. I would just ask that be rescheduled. Obviously that's not
my primary concern at this point. So I think if she wants to observe a visitation, I think that's probably beneficial to everybody. But we'll have to just forego that for this week, and that'll need to be rescheduled. So we'll review this on the 1st, and I'm going to reserve fees until the 1st as well.
and then I can just do a cleanup order that just references what you've ordered today. We can just address that next week as well. Ms. McLean, if you want additional time, but it's going to be very simple.
Yeah, well, my first day back in the I'm hoping to be in there Tuesday morning. So
Okay.
Wasn't planning on, yeah.
I understand that. I appreciate Ms. Baldwin preparing that order. Hopefully we'll be able to enter it next week, but it's pretty short and to the point. So hopefully both parties understand what needs to happen between now and next Tuesday.
So, but you understand that I'm not going to have written objections.
I do. Yes.
Okay. I understand.
And we'll deal with that on the fly next week.
Thank you.
All right. Thank you. Good luck. If you were here earlier, I started going off on my notes about this case when another case was called. So this is Ms. Bosch here and Ms. Anderson here. I had a brief conversation with Commissioner Carmi, who heard this case. I've reviewed the original orders or the proposed orders. And I guess Ms. Anderson, I didn't see any objections to those orders. Is there any questions or concerns?
I absolutely objected to most of what I was sent by Ms. Bosch, and I sent an email back. I believed from what Commissioner Carmi said that we were going to base the schedule off of my parenting plan, and that's not what she sent me. Many of the days were only for the petitioner. I had a different schedule for summer listed in mine. I put, back and forth on many of the holidays, and he wanted them for every one of them. So I had written her back, and she said I was wrong, and that's not what Commissioner Carmi wanted. So I very much objected to.
You didn't file any objections, though?
I didn't.
So I wouldn't know about any objections.
Okay. Well, I don't have a lawyer, and I didn't realize I needed to do that.
I just want to make sure that I'm not, that there wasn't something that I'm supposed to see that I'm not seeing.
No,
okay.
I didn't know I was supposed to file anything, because she said, if you agree on it, submit it. If you don't agree on it, come to the hearing. So that's all I understood.
All right. Just hold on for one moment. I'm going to put everybody on. I'm going to pause and see. This may be better to be in front of Commissioner Carmi because it sounds like it's not as cut and dry as we assumed that it was. So hold on, let me see when we can get a time for Commissioner Carmi. So just one moment. Okay. Thank you for your patience. The we're going to check to see if we can set it for next Tuesday at 1 on the commissioner presentation docket, but I don't know that for 100% sure yet. So I'm going to ask you guys to hold on for one moment. I'm going to take this other matter and hopefully we'll then have an answer. Okay. So I appreciate your patience. So let's call the Rogers and Burton on for review.
Matter's ready, Judge.
All right. I showed that this is on for a review of the interim GAL report. I'm assuming that all parties received that last week.
We did, and both parties, I think, scrambled to get responsive pleadings out, not knowing if today was going to be review for changes or just to review to make sure that everybody had capitulated with the GAL process and had gotten in to meet with Ms. Height. And as usual, she was very thorough and quick in her investigation, which is very much appreciated. Don't know where we go today. If you want argument or kind of what the intent of the court was last month or a couple months ago when we heard this initially.
Well, I see some declarations were filed by both parties and I reviewed those. Those were on the 20th. So Ms. Rogers and Mr. Burton's responses. Neither party really specifically asked for a change. So I guess I'm willing to discuss that today if the parties are in agreement that we can do that.
That's fine.
All right. Let me pull up my temporary parenting plan. So we are currently professionally supervised visits up to 3 hours per week. All right. Okay. Whoever wants to start, go ahead.
I'll go ahead, Judge, since my client is the petitioner in this matter. And I'm going to be quick in my comments, I promise. You have reviewed my client's declaration. I think from a starting point, this is a case where I think everybody is encouraged by the progress, although it's progress in a very short and limited amount of time. Mr. Burton has exercised visitation with Asher. Again, to refresh your recollection, this is a case in which Asher had very minimal contact with his dad over the past several years. It's a case where my client did try to accommodate and effectuate some kind of visitation. And depending on who you believe on that, the reality is it just didn't happen. So we're basically starting from scratch with this relationship. Are encouraged by the professionally supervised visits at Reconnecting Families. There's been 7 of those. Of the 7, 1 commenced late, and I think everybody agrees with that. Initially, you had stated that you wanted to see some kind of track record and level of commitment from Mr. Burton to see if he was serious about visitation or if this was promulgated by the request that my client had made back in the fall related to child support. He has exercised his visits. Ms. Height has provided and conducted her preliminary investigation. But at the end of the day, we've got, again, we're still at the infant stages of visits and how is this going to progress. Now, my client details for you several concerns. And again, the history of this case cannot be understated, given that it's a case where Asher is essentially starting over with dad and trying to get comfortable in that relationship. My client, although she's reviewed the GAL report and again is somewhat happy or relieved that things are progressing in a good progressing to the point where hopefully we can get to that point of standard visitation. She expresses concern to you. Those concerns are reasonably based, again, given the history of this case, that doesn't want to put essentially the cart before the horse. And that is assuming that things continue to progress. My client would like to see and feel most comfortable with a couple of more months of professionally supervised visitation. Again, build that track record that we just don't have at this point, and then slowly progress and transition into more liberal and what I would call standard visitation, which I think is where Ms. Height is trying to go with this. This is a child, again, that it's only known mom as provider, has only known mom as the caretaker. This is not a case where these parties were together much of this child's life. And this is a case where dad, for one reason or the other, has been largely absent from this child's life. And again, the court is charged with promoting the best interest of this child. We are concerned that giving too much too fast is certainly not in Asher's best interest. We believe, and my client has stated, based on her experiences since visits began, which was anticipated and again, not unexpected, has taken a couple steps back in things, regressed a little bit, although it's encouraging. He's excited. If you look at the GAL report and the visitation notes, to see dad and spend time with dad, again, it's new for him. It's a new process for this little guy who's again trying to essentially start from scratch to build that relationship. We do think that over time that will build up. We do think that consistency over time, again, will give more confidence to my client and the court alike that Mr. Burton is serious about this, that this isn't going to be one of those things where the spotlights are on through litigation and he rises to the occasion only for litigation to die down and he kind of drops off, which we routinely and commonly see in these types of cases. We want a pattern of, again, a visitation that this little boy is going to have a dad in his life, and dad is going to be there for the long haul, just on a temporary basis, not through the next couple of months. That's my client's request. And again, it's reasonable given the circumstance. My client would like me to remind you, and again, reasonably based, that since Mr. Burton has been absent, she has done the lion's share of all the caregiving, and not only emotionally and physically, but financially as well. She's been the party that's gotten this child engaged in the speech therapy and the speech classes. Interesting, from the visitation notes, Ms. Fellows indicates that child is somewhat slow to warm up to dad. It takes a little while. And again, that's not unexpected given the length of the absence between dad and this child's life. Building on that, building some kind of a foundation moving forward is appropriate. Giving this child too much too fast is a concern. And again, that's reasonably based. If the court does and is inclined to adopt the GAL recommendation or some variation of that, we would just ask that you contemplate some of the dates that are contained in my client's declaration. Specifically, August 19th is my client's birthday. She would like that. Now, she also has some plans for the family through the remainder of the summer. Again, I think that's reasonable given the history of her caregiving of this child. And she asked that the visitations be, if you are going to change that, some kind of an alternating pattern to accommodate some of these activities that the child otherwise has planned. And instead of Saturday, that the visits be Sunday, as that works better for scheduling issues moving forward. Finally, this is a child, again, who is athletic in nature. That's good. That forms a base of confidence for him moving forward. He's successful in that. He excels in that. And that builds kind of his self-esteem. A child will be starting soccer in early September. He will obviously have games on Saturday, and we absolutely want Mr. Burton to participate. We have no doubts that he will. We want Asher to be exposed to these people who love him, want to encourage him and watch him succeed. I think that benefits everybody, especially this child. Hopefully that will also manifest some kind of trust between the parties, because right now there's not a lot of trust between them. And again, given the absence, that's not unexpected. But we would like an order that visits commence after Asher's game if the court's entitled to grant day visits. Also an order if the court is going to bump up that visitation that requires each parent to get the child to his games and practices and activities on time over his or her respective times. Again, I think that is kind of where we're at now. Moving forward, we would just really advocate the position that proceeding again with a little bit of caution for this child, knowing the significant absence that's been in his life for a period of time, and not forcing what we hope all comes in time, but not forcing that relationship prior to the child being ready. And I think that's kind of paramount to my client's concern in this.
Sorry, I'm muted. Good afternoon, Mr. Burton. Go ahead.
Good afternoon. Thank you. I would just like to say, for the most part, I disagree with most of what Mr. Zandy's saying. The visits have been going great. Like he said, though, the first couple were slow to get started. Granted, it's a new environment. Pretty shy as he is, but as more visits happen, it was very clear how much he opened up and to becoming the Asher that I know, where he's a little more rambunctious, a little more hyper in a sense. And that's the true Asher that he is. He loves the time that we have. And I feel like that we should it should progress in a way that leads up to being the final step. So with what the GAL recommended, I mean, I agree with all that. I feel like we should do longer intervals. He's shown that throughout the report and through what I've witnessed that he's more than comfortable with hanging around me. He's asked to play video games, but was met with Mr. Rogers' answer of no. She said later on we can possibly entertain that. But I feel as though I deserve quality time with my son. I've done everything. We've actually had 9 visits from my records, and the one I was late to by 11 minutes, that was due to the 4th of July traffic. But it wasn't intentional on anything. It's stated in Mr. Rogers does intend on wanting me to participate and be active in his life, but continues to fight pretty much every step of the way, kind of taking that from me. I just want more time, and it's pretty sad that it's where it is right now. So I would request that Your Honor review again Miss Ann's statement and adopt that.
All right. Thank you, Mr. Burton.
Thank you.
Are you and Ms. Rogers able to communicate or using a parenting app? Or
I have no problem with that. Yeah. I mean, the end goal is to ultimately co-parent effectively. It's all for our son. And so I'm willing to do whatever it takes to make that work.
okay. Here's what I'd like to do. I do think that there should be a measured approach. I appreciate Ms. Height's report, and it's thoughtful as always. And I do. Ideally, every parenting plan would be 50-50, assuming there's no concerns or issues. I understand Ms. Rogers' concern because there was alleged to be a longer period of time where Mr. Burton wasn't completely involved in the child's life. And so this is new, and I'm sure she's being protective, and I understand that. Also understand Mr. Burton's want to have a relationship with his child. So I appreciate that we're progressing. What I'd like to see is 6 weeks of weekend visitation that was contemplated for the month of August by Ms. Height. So just as a reference point. So the 6 hours a day, no longer professionally supervised, with Mr. Burton. I would very much like to accommodate the dates that Ms. Rogers outlined. And I don't know if I need to just list out the days or if the parties are able to communicate. And I want those weekend visitations to continue a few weeks into the school year so we can see how that, because this little guy is probably overwhelmed right now. And then you have sports starting and then school starting shortly thereafter, and having weekend time that's going to impact not only visitation with dad because of the sports, but there's just a lot going on for him. So I guess, do you have any problem, Mr. Burton, with, as I look at the calendar coming up, the 5th of August, which would be a Saturday, the 13th of August, the 20th of August, and then the 26th of August.
Alternatively, I could do too, Judge, is just put some dates together, and then and I agree with him when he states that they need to co-parent and learn to communicate. I think hopefully in time they will get to that point. Maybe this is the first step in that. I can craft that order on what we're doing today, plug some dates in there, and if Mr. Burton, it's not going to work for him, we have scheduling issues, he can contact me and we can iron that out. Or alternatively, we could just save those for maybe a presentation in 2 weeks.
Okay. It sounds like he doesn't care if it's a Saturday or Sunday. Is that correct, Mr. Burton?
That's correct. Yeah.
Okay. So it seems like he's willing to work with the few dates in the next month that she would like to work around. And I would propose essentially a review September 12th to see, so weekend visitations through the weekend of the 10th of September, and then let's just see where we're at. And at that point, I know Ms. Height's recommendation goes to overnights, and ultimately that's what the court wants to consider. And and look at, but I think a kind of a little bit of a measured approach is appropriate here. Just to ensure that he is doing okay in managing everything, including new school year, sports, all of that.
Your Honor,
Yes, Ms. Height.
would you consider starting those Saturday/Sunday visits this coming weekend, the 29th and 30th, or do you want to just start them on August
That's
5th?
what I was going to request as well. Yes.
Barring any previous scheduling, like, or if there's any trips or plans this weekend, if that can be made to work with Miss Rogers, then I'm fine with them starting this weekend. If she has other plans or isn't available to do that, then they must start the weekend of the 5th.
Thank you, Your Honor.
And then, Mr. Zanni, do you want to set a presentation date?
Yeah, I think that's probably a good idea. Is there any, and I had to log on late, I was on the adoption docket. Is there any availability next week? I think I can turn an order around pretty quick.
I have a spot left next week. Do you want to take it?
If we can have it for presentation, Mr. Burton, I'll craft a quick order. I don't think we really need a parenting plan since this is very interim. So I'll just put it in an order form and just set those dates out. And give me a day or two to talk to Courtney, and then I'll email you that, take a look at it, and then let me know suggested dates if it conflicts or you have other plans, and we'll kind of work through it that way. Come back next week and we'll present that, judge will sign it, and we'll lock into those days pending that review in mid-September.
Sounds good.
All right. So I appreciate you both. We'll set this matter to August 1st is next Tuesday. So at 1 p.m. for a presentation.
And last issue, I don't want this to be a problem. There seemed to be some dispute as to the exchange location for Asher. My client had asked that occur in Lexington. I believe the GAL recommendation was Kalama, maybe. Do you have any Kelso, Target, Kalama, Lexington, any preference on that?
I thought I saw Lexington Chevron.
Yeah.
Is that
Lexington Chevron? You're correct.
That's what Ms. Height's recommendation was. Not knowing where everybody lives, I'm going to trust Ms. Height on that. So it's a great Chevron. Go there.
Okay, fair enough. I'll craft that and we'll put something together. And do you want me to leave the times, not designate the 6 hours, but maybe just let both parties talk through those and hopefully resolve that prior to next week?
I think that's a great opportunity for them to work through that. And then if I need to make final decisions, I'll be happy to do that next Tuesday.
Sounds good.
024108. First and foremost, just want to make sure everybody's contact information, please make sure your contact information is up to date in the clerk's file. And we will set this to 1 p.m. August 1st. So next Tuesday. But it will be on it's called the Commissioner's Presentation Docket. So same time and date as this docket would be, but it's called the Commissioner's Presentation Docket. And that's a Zoom link. So just make sure you're looking for that instead of this docket. And I will make sure that the proposed orders get to Commissioner Carmi.
I appreciate that, Your Honor, although I was looking forward to being able to be in front of you this afternoon, but I understand and think it's probably best that it go back to Commissioner Carmi so we can have her
I would agree.
Clarify some things. So
all right.
Thank you so much.
Just to clarify real quick, do I need to officially object to what she's proposing since it hasn't been filed?
Technically, yes. Okay. So if and they can just be bullet points, but and make sure that she receives those as well.
Okay.
And Ms. Wade, do we have anything else?
Thank you so much, Your Honor.
All right. Thank you. Good luck.
I think it's Duke and Duke, Your Honor. I think we.
Oh, did I?
That's all right.
I know there's
been on me. I was waiting in what was called a presentation docket elsewhere. I guess that was
okay. So Duke
and
Mr.
Whitner. Sorry, Mr. Whitner, I didn't mean to interrupt. I've spoken with him and we've exchanged my objections last week, and he made those changes. I have signed off on that order pending Ms. Powers' approval. I did not see that her requested changes were included in the order, but I don't anticipate they will meet any opposition, as they look like it's pretty standard from the state's perspective. I think with that said, hopefully pending again input from Ms. Powers, we can present those probably this afternoon or first thing tomorrow.
changes actually have been made, the changes that Ms. Powers requested, and had my paralegal draft those during this docket and circulate them to Ms. Powers and Mr. Zandy. So those should be in your inbox. So I think we're all in agreement.
Okay, perfect. All right, wonderful.
I didn't see those. Sorry, Mr. Whitner. That's a long-winded way of me saying I think we're agreed.
Those are my favorite kinds of cases, so I appreciate that. I will get those signed and filed as soon as I receive them.
Thank you.
All right, thank you.
Thank you.
All right, now, Ms. Wade, I think we're done. Do you see anything else we need to handle?
I don't see anything else.
Beautiful, thank you.